All right, let's go ahead and go through these, ready or not. And the most important reason, or the most important thing about this is not what necessarily the answer is, but the reason for the answer. So we'll talk about the reason also. So number one, you're interviewing a job applicant. You see on the employment application, the applicant attended the same high school that you attended. Is it okay to ask the applicant when he or she graduated? So for example, I went to South High. Oh, you went to South High? So did I. When did you graduate? So that okay? No, why not? Age. What about age? Okay, so you might find out when asking the applicant when he or she graduated how old that applicant might be as a result of the fact that most people graduate high school when they're 17 or 18 years old, and that was how long ago, and put that together. And if they're 40 and older, then you've got a problem because that's when age discrimination kicks in. Okay, so easy one, we know that one. Number two, is it okay to throw away the employment application of someone you choose not to hire? No. Do you have to keep it for forever? No. How long?
2 years.
2 years. Yeah, I went 2. 2 years. Yeah, and if you want to keep it a little bit longer, that's okay too. And you can keep it on electronic file also. You don't have to keep the actual copy. But why would you keep an employment application of someone you don't even interview for a couple of years? In case they feel that they've been discriminated against in hiring. And so they go to our friends at the Fair Employment and Housing Commission and they file a complaint with them, and then they come in and they want to see why you hired the person you did versus the person who filed the claim. And you want to have that documentation on file so that you can demonstrate, look at their application versus the person that I hired. You can see why I hired the person I hired instead of this person. Okay. Number three, Harold wants to look at his personnel file every week to make sure nothing is being put in there without him knowing about it. It's his personnel file, so he can look at it whenever he wants, right? No. How often does he get to look at it? Well, what law says is whatever is reasonable. Yeah, so I always love the reasonable. Whatever's reasonable. Yeah, so how do we decide what's reasonable? Well, it depends upon how big your company is. And so if you've got 400 people, people don't get a look at their personnel file every day. That's just too much work for HR. And so for 400 people, maybe once a quarter they could do. Now, new law went into effect as of January 1st regarding personnel files. Anybody know what that new law is? No. It used to be just that employees could have copies of things that they had signed or disciplinary action taken against them. And now they're saying no, that they get the whole shebang. And so that's one of the things to be aware of. Number four, Bill has cancer. You're a Bill supervisor. Lots of people have been asking you, when's Bill coming back to work? What's going on with Bill? You're having a staff meeting tomorrow. Is it okay for you just to make an announcement? Bill has cancer and this is what's going on with him. No, why not? HIPAA, yeah. So HIPAA has two parts to it. And one is that your medical files will be maintained securely. And then the other part is that no one's going to be talking about your health when they're gabbing about you. Now, if Bill wants to send an email to everybody that says, hey, I've got cancer and this is what's going on with me, that's fine. That's Bill's deal. But that's not your deal to talk about it. 5, Bev just called and quit. How soon does the company need to get her final paycheck to her? 72 hours. Very good. 6, you've decided to fire Sue. When does the company need to get her final paycheck to her? At the time of termination. Well, here's the deal. I had a client who wanted to fire somebody and had the final paycheck, but that person wouldn't show up to work so they could fire her. So then what do? You mail it. Yeah, you're fired. Here's your paycheck. Very good. Number 7, Sue is still in her introductory period when you terminate her. She's accrued vacation time, but she's not eligible to use it yet. Do you have to pay her for that accrued vacation time? No. Yes, you do. Yes, okay. So here's one of the things that I wanted to tell you about also. Notice I said introductory period here. I did not say probationary period. If you have a probationary period, especially if it is in your employee handbook, I strongly encourage you to get rid of the word probation and use introductory. Anybody know why? Probationary period implies that once you pass probation, then you're good. right? And so for those of us who have worked for union organizations, you know once you pass probation, you have to about kill somebody in order to get fired, right? So probationary period, at-will employers don't have probationary periods because you don't put people on probation unless you're unionized. And so say introductory, the only thing that changes after the introductory period is the fact that your benefits kick in. That's the only thing that changes. So you don't want to imply whatsoever once you pass that introductory period, you're good, because you don't want to ever tell an at-will employee you're good, because if you do, then they are. You have to fire them for cause after that. If you imply to them that you passed it, we're fine, we checked you out, you've checked us out, it's all good. So all you want to do with that introductory period, if you even have one, you don't have to have one, the only reason you should have an introductory period is to say your benefits kick in once the introductory period has been passed. Other than that, don't even have an introductory period. There's no reason to. Okay, so yes, you have to pay people vacation time if they have accrued it. If you have PTO instead of vacation and sick leave, but you lump it together, you have to pay them. That is considered wages earned by the state. Okay, any questions about page 1? All right, have you learned something already? Very good. Go to page 2. Now let's just go through this together, shall we? Or do you want to do the answers yourself and then be quizzed on them to see if you got them right, or does it matter to you? Some of us are competitive and we need that kind of challenge, but if you're not, let's just go through these together. Number 8, employers are required to pay unused vacation and sick leave to terminating employees. False. Why is it false? You're not required to pay sick leave. That's exactly right. Only vacation time or PTO, if you have PTO where you lump them together. Number 9, Sherry needs to leave a few minutes early today, wants to take her 10-minute afternoon break at the end of the day so she won't lose any time. Is that okay for her to do that?
No.
Why not?
It's required that every 2 hours after lunchtime she has to begin the 10 minutes break, so that's the...
Okay, so that was really true. Yes, sir?
The law just, with the state Supreme Court, isn't that just change? It's not my responsibility or should you take your break?
That's exactly right. And so this answer used to be, no, it's not okay for her to do that. As a result of the Brinker decision last year, yes, it's okay for her to do that. So one of the things, the law said that employees are non-exempt employees, hourly employees, are entitled to breaks. And the break should be midway between their morning and midway between their afternoon. And their lunch should be just about right in the middle of it, okay? Now, used to, employers were not required to ensure that employees took their breaks, but they were required to allow them to take their breaks. And so what they wanted to do is you take it midway, and that's what the law says, and we're all good and fine. Now, as a result of the Brinker decision, they say, you know, if your employees want to take their breaks, fine. If they don't want to take their breaks, fine. Whenever they want to take their breaks is fine. You have to ensure that they get a break. You're not required that they take the break, okay? So you say, hey, you know, you get a break, and they go, I don't want to take a break. Okay, that's fine. You don't have to. And that also applies to meal periods now. So here's the deal. This is where it gets tricky. You've got to make sure your supervisors are very clear on the fact that they're telling people, you get a break if you want one. You get a meal period if you want one. And if the employee says, I don't want one, fine. Now that's very different than how it used to be.
What's the best way to document that? So when somebody says, oh, well, they never
allowed me to have it.
I my lunch this day, and so...
Yeah, well, that's why one of the best practices is just forget the Brinker thing and stay on course on that. You take your break midway. We document that because you clock in, you clock out. You take your meal period at 6 hours. You clock in, you clock out. And so that's a best practice. If you want to do that, you're allowed to do that, to say, we're just going to stay the course because this just muddies the water and gets everybody all confused. So you can do that. But if you want to do you get it, you can take it if you want to. Make sure you've got a waiver that they're signing that says, I didn't take it, or I didn't want to take it.
We're running into overtime issues now as well, because if you didn't take your break, whether you wanted to or not, as an employer, you're paying that overtime.
There you go. Very good point. So if you want to stay the status quo where you're requiring them to do that, that's fine. Go ahead and do that. Because that is one of the things. If you don't, you run the risk that they will come back and say, well, you never allowed me to have a break. You may have a supervisor who you think, or he thinks that he's communicating what the law is, but is not doing a very good job at it because people don't communicate things very well, translate things very well. And the other thing is that then you get into overtime issues if they're not taking their meal period. They don't have to take their break and you run into overtime. But if they don't take their meal period, then you'll have to pay them overtime.
Would it be okay if they just clock in and clock out as per their time, but they don't want to take that break? Would it be okay? That in this way, it will be documented in a way. At the same time, if they don't want to do it, that's fine.
I don't like that they're clocking in and clocking out, but not actually doing it, because then that gets into them being able to say, well, you made me clock in and clock out, and I didn't really take my break. So yeah, so I'm more of the let's record what's actually happening, because that's going to be our best defense.
Or if they get hurt during that 30 minutes.
Exactly.
Yeah. Okay, so the answer to this question is yes, it's okay for her to take her 10-minute break at the end of the day, because it's not really going to affect anything. But again, we've discussed the issues. All right, so 10, Sherry wants to work through lunch so she can leave early. Is it okay to allow her to do that?
If it's within 6 hours.
Well, and the thing is, yeah, I mean, now it's not even within 6 hours. That's old, because 6 hours was, you can work up to 6 hours without a meal period. And then if you work over that, then you've incurred a penalty at this point. But now that Brinker has passed, it's okay for her to...
No more penalty?
There's no more penalty unless she works over the 8 hours. So if she wants to work through her meal period and leave by the 8 hours, then there's no penalty.
That falls under the Brinker too.
That's exactly right. Yeah. But again, this might be all too confusing for folks. So if you want to stay with the old rule, then that's perfectly fine.
For us in healthcare, like we operate operating rooms, of course, that's always a huge challenge.
Yeah.
Because most of us would rather just keep working and leave a half an hour early.
Yeah.
And go in and grab just a sandwich bite and go back to work. So.
Yeah. And that's the thing, is that Brinker allows that, which is nice, because the thing is, under the old rule, it was employees are kind of treated like children, and that they have to, have a break whether they want one or not. And if they had stuff that they needed to do and wanted to take their lunch hour later, they weren't allowed to do any of that stuff. And so now what the law says is that, yeah, people can be adults and make their own decisions. The requirement, though, is that they are allowed to take the meal period when they want to.
Robin?
Yes.
One more thing on that. From a business decision, I don't have to allow someone to leave a half hour early. I want you to take your lunch from 12 to 12:30, because you didn't do that. From a business decision, maybe I'm just going to document that and maybe write you up. My business needs you here till 5. And just because you want to go home, just because the law says it, doesn't mean I have to allow you to do it.
Absolutely. Yes. Thank you for making that distinction. Yeah. Just because an employee wants to do it doesn't mean that you have to allow the employee to do it.
Should we, if that does happen, if we decide as a team we want to just work through the day, is there a form we should have that everybody signs at the end of the day?
That says I was allowed to take my meal period and chose not to.
Okay.
Yeah.
And they need to sign that every day?
That happens.
Yeah, I would say that would be a best practice, to do it every day, or to have it on when they clock in and they clock out, or something like that. Because the thing is, this is one of the reasons to stay old school. It doesn't make you vulnerable to people going, well, that's not how it really happened. Okay, so if you do old school, you clock in and out for your breaks, or you don't, but you clock in and out for lunch by the end of the 6th period, all of that kind of stuff. Then you've got that documentation that is hard to refute. Okay, but if you have this, well, yeah, you can go if you want to, and don't go if you don't want to, and all of that, and we've got all of this paperwork that we've got to record that says you had the right to go, but you chose not to go, that kind of makes life a little bit more hectic. So again, as the employer, you get to dictate the rules. Just because the law says something doesn't mean that you have to allow employees to do whatever they want.
So, I think you said if the employee were 8 hours or less, they could choose to waive the
Well, again, they don't have to take the meal, but you'll have to pay them overtime if they work over 8 hours.
What about a 12-hour shift?
Well, and that depends upon your wage orders. So that's one of the things you should know, that there are like 12 or 16 different wage orders in the state of California. You have to adhere to the one that governs your industry. Healthcare industry is different than others. Yes?
Is there a way to just do like a blanket document at new hire? We will allow you to take breaks and lunches.
Mm-hmm.
You choose to waive them on your own and have them sign it? Is that way it's not every single day?
Yeah, and the thing is that, again, this is all very new and very fresh, and there have not been lawsuits yet as a result of this. So whatever documentation you're going to put out there is, you're the pioneer and you're charting the course for it, okay? And so if you have one documentation that they sign at the very beginning that says, I get to take my meal periods and my breaks, and if I don't, then that's my choice. That's a little too iffy for me, because I could see people going, well, I really wanted to, but my supervisor wouldn't let me. And so that was a blanket document that they made me sign at the very beginning when I signed up. I didn't even know what I was signing. All I know is that my supervisor never let me take my lunch. So that's risky. That's risky.
See, I see this as a huge advantage for me working in the operating room, because I'm always the one who has to, as the supervisor, go break everybody.
Yeah.
I don't really have staff to do that.
Yeah.
So I'm the one that does it, but I'm a working supervisor. So I see this as an advantage if, like, because usually come up to 6-hour thing, I'm like, oh crap, I got to get around, but I have to have an RN in the OR and all that. So to me, this is an advantage for medical for the 8-hour shifts, is that I don't have to worry about the 6-hour thing. It could be 6:15 or 6.5 hours. So
Yeah.
and I know that we're going to be done at that time.
Yeah. Well, the huge criteria here, or the huge requirement, is that employees have to know, I can take a lunch if I want to, I choose not to. All right, and that has to be the constant message from supervisors, is you get to take a lunch period. And if the employee says, I don't want to, then that's their deal, okay? But that's where it gets tricky, is that I'm sure that there are going to be employees who say, well, that's not what my supervisor said, and I just didn't, and okay. But again, we had Brinker last summer. There's not been any lawsuits yet. So we don't, it's uncharted territory at this point.
But it's the time thing that has been taken out of that.
The time factor is that it used to be that the employee has to start their meal period by the end of the 5th hour. So if they start work at 8, they have to start their meal period by 1. That has been relieved.
Okay.
And what Brinker says is that they can take it whenever they want to, as long as the employer says okay. And they can choose not to take it at all if they don't want to.
Okay, now what about after 3 hours of work, we have a huge break in between cases? Can I go to them and say, I need you guys to take your break now?
Mm-hmm.
I can still do that, because that's obviously best practice for the...
Yeah, because what the law said was that it has to start by the end of the 5th hour. It didn't say...
You may not be convenient at 10 o'clock, you may not be starving,
Yeah.
but that's the only time that I don't need you.
Right. The law never said it has to be between here and here.
Okay.
It said it just has to start by the end of the 5th hour.
Okay.
But Robin, if they don't sign a waiver and they can come back and say, you owe me all these hours and penalties, and it could really run.
That's exactly right. So that's why employers are allowed to say, you know what, I don't care what Brinker says. We're doing it this way. Or if you say, this is the way we're doing it, but if somebody comes in and goes, look, I got to take my kid to the dentist at 2, can I take my meal period? Then you go, yeah, you can. Sign this little waiver that says you're choosing to take it, or you're taking it after the 6th hour, or what have you. Yeah. So, yeah, so the law is supposed to make it easier, but sometimes it just muddies the waters a little bit more. All right, number 11. You should get the answer to this. Sherry came to work at 8. She wants to take her lunch break at 2 so she can take her daughter to a dentist appointment. Is it okay to allow her to do that? Yes, now it is. 12. Sherry wants to eat her lunch at her desk because she doesn't want to walk all the way to the break room. Is it okay to allow her to do that?
No, as long as it's no work is being.
That's exactly right. Yeah, and the thing is not even at her desk. At my previous place of employment, one of the things we told the non-exempt employees is get out of the building during lunch period. Because just because you walk down to the break room doesn't mean that somebody's not going to come and bother you while you're in the break room. But the danger of allowing somebody to eat lunch at their desk is that if the phone rings and they pick it up, now they've had an interrupted meal period. And what the law says, regardless of Brinker, is that people are allowed to have 30 minutes of uninterrupted meal period. And if they pick up the phone, it's interrupted. If somebody comes up and says, hey, where's that file? It's interrupted. If they get an email that they respond to, it's interrupted. And so that's why you want to get people out of the building. And by the way, when you're out of the building and somebody calls you on your cell phone and you see it's work, ignore it. All right, so that's for your non-exempt employees. Now remember, with your exempt employees, they can work 24/7. And none of these rules apply to them. Yeah, those of us who are exempt, yeah. None of those rules apply to them whatsoever. It's just your non-exempt hourly employees. All right. 13, you are required to ensure that employees you supervise take their 10-minute breaks in the morning and afternoon. No, and you never were required to ensure that they take their breaks. You were required to allow them to take breaks, but you never had to monitor are you taking your break or not. As far as the little rest period was. 14, you're required to ensure that employees you supervise take a 30-minute meal break. Well, according to Brinker, now you're not required to walk around behind them and going, did you take your break? Did you take your break? Did you take your break? You're not required to do that anymore. But you are required to ensure they know that they have the right to take a break. Okay, so that's why, again, you want to make sure that they're clocking in and out and you're looking at those timesheets to make sure that if they're not taking any breaks whatsoever, you check in with them and go, what's going on? Why aren't you taking your breaks? And if they say, well, because we were too busy and my supervisor said I can't let you go right now, then you got a problem.
Is it the responsibility of the employee to take their breaks, or it is necessary for the supervisor to send them to?
Yeah, so now it's the responsibility of the employee, but the big, giant burr in the whole thing is that you've got to make sure that frontline supervisors are letting them know you get to go if you want to. And that's where things always get messed up, is with that translation. You're HR person and you're telling your supervisors, and then your supervisors go out there and it's a whole different story, right? It's just like the telephone game. You start, and then by the time it gets to the end, it's a whole different story. And so that's why it's imperative that supervisors know what to communicate. It's in writing, and they're constantly communicating to people. You have the right to take your breaks and meal periods, and if somebody prevents you from doing that, let HR know or whoever. Yeah. All right, 15, your employees are required to eat on the premises. Are you required to provide a place for them to do so? Yes, yes. Yes, you are.
How is that possible for people that work like out in the field? So if you are out in the field doing a job and they have to have a lunch, so they take a lunch, it's not our premises. They can't use their break rooms because it's not our work.
It's right, yeah. And so that's the thing, is that, again, with your industry where it's oil or something like that, your wage order probably differs on this than the majority. But if, say, like at a healthcare facility, and they're saying everybody has to stay here, then that's what the rules are for them. So thanks for bringing that up. Yeah, that's one of the things. If you don't know what your wage orders are, look them up. All you have to do is go to the IWC website, and look through all of the different wage orders and find the one that applies to your business, to your industry. And most of them are the same, but they differ. And so for oil, it's different. For ag, it's different. For healthcare, it's different. And so make sure that you find yours. One of the reasons you want to find it, you're supposed to post it up on your bulletin board where you've got all of your posters. You're supposed to post that wage order so that everybody can see what the rules are for your industry. So,
That requires you to not leave.
I'm sorry, say again?
If I require someone that you cannot leave during lunch,
Uh-huh.
do I have to pay them?
Yes. Mm-hmm. All right, next page. You are required to provide rest and meal breaks to your part-time employees.
Depending on how part-time.
How part-time they are, yeah. And so anybody know what the law says? How many hours do you have to work before you get a rest break?
2 hours.
3.5. 3.5 hours. Yeah, so 3.5 hours will get you a 10-minute break. And then if you work over 6 hours, then you get a meal period. So here's one of the things we're tossing around, that 6 hours there. If you have a part-time employee that works only 6 hours a day, they can waive their meal period. But the thing is that they cannot work over 6 hours, not 6 hours and 1 minute. And if they do work over 6 hours and 1 minute, doesn't matter if they've waived that meal period or not, you owe them the penalty. Penalty is 1 hour of wages. Okay, so with part-time employees, you want to make sure that they're only working like 5.5 hours. In case they happen to go over a little bit, they still don't get that 6 hours. All right, 17, you need to hold a staff meeting. Lunchtime is the only time that everyone is available to meet. Do you need to pay the employees for their time if you're providing the meal? Yes. And I put this one on here because I had a client who said, but I'm giving them their food, so I shouldn't have to pay them. No, you still have to pay them. And here's the thing, is that if you're doing it through the meal period, you still want to give them a half-hour break before or after. All right, 18, George regularly works in Bakersfield. However, the company needs him to work at one of the out-of-town sites tomorrow. Does George need to be paid for his travel time to the out-of-town site?
Yes.
Yes. How much does he get paid? What you do is deduct the regular commute from the total commute, and you pay him whatever the extra is. So if it regularly takes him 10 minutes to cross town to get to work every single morning, and you're asking him to go to McFarland, and now it takes him 25 minutes to get there, you only have to pay him for the 15 minutes of travel time. Okay, it's regular commute. Yeah, a regular rate. Now, if they're traveling constantly, you can pay them at a lower rate. The travel rate that you can pay them could be minimum wage if they're doing it all the time. And so they travel for an hour, you pay them a travel rate, then while they're on their job, they get paid their regular rate, and then while they're traveling back home, they get their travel rate. So you can do that, pay them the travel rate at the lower rate. But if it's just one, you go into McFarland tomorrow, then I wouldn't kick a travel rate in there. It's going to be too hard to figure out the computation on how much we have to pay this guy. All right. 19, Harold works overtime without being told to again. The last time he did this, you told him he has to have permission to work overtime in order to get paid. Does he have to be paid the overtime?
Yes.
Yes. And so is there anything you can do about it? Write him up. You bet. So that's one of the things, again, I had a client who said, I'm not going to pay them overtime. I told them that they're not told to work overtime. They don't get to get, no. You pay them, you just write them up. 20, you distributed forms to employees that they're required to complete and give back to you. Some employees haven't turned their forms in, even though you repeatedly told them to do. Is it okay for you to hold their paycheck until you get those forms back from them? No, you don't get to hold their pay hostage. All right. So what do you do instead? You write them up. All right. 21, you asked Jill to work overtime. She refused. Is it okay for you to discipline her for refusing to work overtime?
Well, it would depend on whether it's required overtime or not.
Okay. Anybody else? All right. The law allows you to discipline employees who refuse to work overtime if under the circumstances, okay? If they say, I can't work overtime because I'm a single mom and my kid's at daycare and I got to go pick the kid up, I wouldn't discipline them for that. Or I'm in school on Wednesday night, so I can't work overtime tonight. I wouldn't discipline them for that. But it's like a situation where you go on, the place is a mess, we've got to meet a deadline, it's got to be all hands on deck, and somebody goes, I don't want to, can't make me. Then you can discipline somebody for that. Mm-hmm. You can pick and choose. The title of this is Ethical and Legal Aspects of Supervision. So I'm telling you what the law says, and then you do the ethical thing with that. All right, 21, 22. Jill has agreed to work overtime. However, she would like to take time off the next day in lieu of overtime pay. Is that okay? Why not? Okay, so here's one of the funny things. If you ask Jill to work overtime and she says, fine, except I want some time off tomorrow, then no, you can't do that. But if Jill comes to you and says, I have a doctor's appointment tomorrow, I'd like to work the hours today so I can take the time off for the doctor's appointment and not get paid overtime, then that's okay. The law allows that, and that's called makeup time. And employees are allowed to initiate makeup time. They are allowed to come to the employer and say, I will agree to this if you do this for me. Yes, sir.
But doesn't that have to be within the same work week or work?
Yes, same work week, and you make sure you document that, all right? But if the employee initiates it, it's okay. They still don't get to work over 11 hours without getting paid overtime. If they work over 11 hours, you have to pay them overtime. But if you initiate it and then they say, okay, but this is what I want, then it doesn't count as makeup time. 23. Your staff wants to work 4 10-hour days instead of 5 8-hour days. You like that idea, so is it okay to change? No. So can you ever change? Yes, you can go to an alternative work week. You have to go through a whole voting process. Paperwork has to be filed with the state. It takes a while. If people want to overturn it, then it takes a while to do that and all of that. But yes, there are lots of folks who are working alternative work weeks. Or they're working 9/80s, which is we work 9 hours a day, and then every other Friday we work half a day. So there's lots of that stuff going on. You just got to go through all of the technical stuff and filing the paperwork with the state before you implement it.
One for all and with all or
No, it does not have to be one for all. It can be a certain department. Yeah, so it doesn't have to be the entire company.
And then, so if they went to like, I don't know, if they went to the 4 10-hour days, at 10 hours and 1 minute, that 1 minute is considered overtime.
That's right. 24, the power is out because of last night's storm. No work can be done. Do the hourly employees have to be paid for showing up to work?
Yes.
No, they do not. This is the act of God law. Law says that if employers can't do business and it's out of their control, somebody hit a power line and all the power's out, there's a storm, the power's out, there was a flood, there was an earthquake, there was Superstorm Sandy, employer doesn't have to pay the employees for showing up to work. Now, here's the ethical thing. The ethical thing is maybe you do that because they came to work, and so you want to reward them for coming to work.
At least paying for 2 hours is kind of.
Yeah. So then that begs the question, okay, so if none of that exists, but an employee shows up and you just have no work for them that day, what's the law about that? You have to pay them at least half of their shift, no less than 2 hours, no more than 4 hours. So if they regularly work an 8-hour shift, then you pay them 4 hours. But if they regularly work a 3-hour shift, or a 6-hour shift, you pay them 3 hours. Okay, so it's half of their regular pay, no less than 2, no more than 4.
Now, is that only if they show up? So like if you say, hey, call me at 7, I'll let you know if you're coming in? Okay.
Yes, so that's if they're scheduled and they show up and then you go, got no work for you. Yeah.
But I have a lot of per diem nurses, which is no guaranteed hours, so I can, my policy really is I tell them if I'm bringing you in, I'm gonna at least keep you for 2 hours.
Yeah.
It's just kind of.
Yeah. Well, and the question that has been posed to me before is, if they show up, how long do I have to keep them here? You're not required to keep them there at all, but you're required to pay them. Yeah. So if you want to keep them there and have them do busy work, that's your deal. All right. 25, you're required to give employees time off on holidays. No holidays whatsoever. Not Christmas, not New Year's, nothing. You're not required, even though we have federal holidays. Doesn't require you to give people time off. 26, your company is closed on holidays. Are you required to pay employees when they do not work on those days? No. And what you can say is that if you want to get paid, then you'll take your PTO or whatever, but we're closed, you're not getting paid. 27, you're required to pay time and a half for making employees work on holidays. No. So again, the law does not see holidays any differently than any other work day. So we have the time and a half thing because of a lot of employers do it. you're working a holiday. I want to reward you for working a holiday, so you get time off. So it's a common practice, and so therefore a lot of people think that it's the law, and it's not. 28, Bill is an exempt employee and wants to take Friday afternoon. Oh, Jeff, leave the room, please. Cover your ears, sing Amazing Grace to yourself. Bill is an exempt employee and wants to take Friday afternoon off. Is it okay to deduct time from his vacation bank for the half day?
No.
Yes, it is. From the vacation bank, not from his salary.
I thought they worked at least 4 hours. That,
You have to pay them for the entire day. Yes, and so that's what it's saying. He wants to take Friday afternoon off. And so he's putting in the morning, and he wants to take the afternoon off. And so what you're saying is that if they work at least 4 hours, you have to pay them? No. So that's why I told you to leave the room. Jeff is my boss. We don't want any changes to the exempt deductions. Yeah, so yeah, that was a law that went into effect a couple of years ago that said if they have vacation bank, a PTO bank, you can deduct that afternoon, those 4 hours from their vacation bank.
And then if they don't, then they just get paid their regular 8 hours for that day.
That's exactly right.
So there's no, I mean, no matter what, they're getting paid for their 8 hours.
If they take a full day off, then that's where that 4-hour thing comes in. If they take a full day off, they have no vacation bank, and they take a full day and they say, I want a vacation, then you can deduct then. But if they're sick and they have no PTO or sick leave, you can't deduct then. But if they're saying, I'd rather go to Disneyland than come to work today, fine, go to Disneyland. You'll have less salary when you come back.
basically, if you work 4 hours, you can go home and it's a free vacation because you cannot deduct it and you have to pay it.
You can deduct it from their vacation bank. You can't deduct it from their salary.
Right, but if they don't have any vacation and they still choose to take the 4 hours off, you still have to pay them for that 4 hours.
That's exactly right.
Either way, you're paying them their regular 8-hour salary or 4-hour salary and 4-hour vacation.
That's exactly right.
And in the red for regular.
I didn't just pay it. I didn't deduct it though.
I know. Keep doing that. We like that. Keep doing that. 29. Bill wore a shirt to work that has tiny swastikas on it. He says the First Amendment protects our freedom of speech, so he has the legal right to wear the shirt. Not at work. Yeah, and this is one of the things people, my First Amendment gives me the right to say anything I want to. No, it does not. 30, Joey has a tattoo on his neck. Is it okay for you to require him to cover it up while he is at work?
Yes.
Yeah. Now, here's a question for you. If Joey has a tattoo on his neck, can you go, I don't want to hire you because you have a tattoo on your neck?
No.
Yes, you can. Yep. Mm-hmm. Tattoos are not protected. Tattoos and piercings, not protected. So, yes, so that's one of the things. Yeah, I tell people that in harassment training. Some people are outraged. But the thing is that there's not a lot of people who are discriminating against people because they have tattoos or piercings. But the law says that, yeah, if you want to not hire somebody because they have a tattoo, you don't have to. That's legal discrimination.
I probably just wouldn't tell them. I just wouldn't hire them.
Yeah, exactly.
But don't you get into a gray area by having one person cover it up, because then you would have to make everybody correct?
Yes.
Even if that's a swastika and that's a teddy bear, you still have to make them all.
Well, actually, no. No. I changed that answer. It's not discrimination if you require somebody to cover up their swastika or their KKK or their devil or bite me or anything like that. Yeah, that's not discrimination to require one to cover it up and one to not cover it up. Yeah. It's better to have a blanket. Everybody covers up their tattoos. It's better to do that. But no, when it comes to discrimination, there is no protection in these areas except one place, and that is religious tattoos. In religious tattoos, there are some religions that require their followers to display their tattoos. Now, Christianity is not one of those. So if you have someone who has a big giant cross on their neck and they say, my religion, this is religious, and so therefore I get to display it. No, that's not part of the requirements of your religion. So that's one of the things. If you missed my presentation on religious discrimination last December, You want to make sure that you're up to speed on the new amendments about religious accommodations as part of the Fair Employment and Housing Act. And so one of the things, Governor Brown expanded the protection for religion and said that you have to accommodate based upon wearing religious artifacts, facial hair, long hair, religious garb, tattoos is included in all of that, if it's reasonable. If it's not reasonable, then you don't have to. But he heightened the criteria, I guess, for reasonable. It used to be if it was a minimal accommodation, a minimal hardship to accommodate, then you didn't have to accommodate. Now it has to be a significant hardship to accommodate. So we haven't had any lawsuits yet. There's going to be all sorts of lawsuits happening, I'm sure, or at least claims with the DFEH when it comes to religious accommodation. Yes, ma'am.
So you're saying if it's a significant hardship, because I have girls coming in saying that their pastors have told them to take Sundays off, just put a letter and say that it's a that's your
Right.
religious holiday, so that's your day of practice. But if it's a hardship on the fact that you have to go and change 16 schedules to accommodate to one person,
Right.
you don't have to accommodate.
Right. But it must be a significant hardship now,
Well,
not a
it's
minimal
significant-
hardship.
It's significant because it doesn't affect just that employee. It affects several employees because then I have to change them all in order to accommodate to make sure that that client's covered for care. And then, and then I could be grabbing, I would just have to deal with a lot of changes.
Yeah. Well, that probably would not be considered significant.
Okay.
No. The fact that I have to spend an hour changing people's schedules,
No, well, it's significant in the fact that it does, let's just say that Joni's been with Mr. Smith for 2 years, and then she brings us in. It's significant in the fact that it does hurt the client, and I mean, it's more emotional significance, but, and then you're also changing, it does have an impact on the business.
okay. Again, there's no white line that says this is significant, this is not. And so if you think this is significant,
Well, if you have, when the word gets out, and you have 20 girls doing it,
that doesn't matter.
okay.
That doesn't matter. I mean, the law specifically says we don't care that other people get uptight and their feathers ruffled about it. The law says we don't care about that.
Okay.
Yeah.
We might as well shut down someday.
Yeah.
Well, isn't it though that you would only have to accommodate the time for them to attend the service? Or is it
No.
the entire day?
Yeah. Because for people of certain religions, it's an entire day. And so, yeah, and I know that because I read a court case about it, where somebody said, I'll give you time off to go do your religious thing, and then you come back to work. And the employer lost on that one.
Is it possible just to not hire him and say a basic requirement of this job is you have to work on Sundays, and if you can't accommodate this job, you're not getting hired?
That is one way around it, is to say you must be, but you got to be very careful with that, because you don't want to say you have to work on Sundays, and if you can't, you need to be able to say that you must be available any day of the week, something like that. But you still need to be careful with that, because there was a lawsuit where somebody said he had to work on Saturdays, and he said, I can't because of my religion, and they said, okay, well, see you, bye, and the employer lost that one. Yeah. So that's the thing. It's up the ante tremendously. And again, there haven't been any lawsuits yet to guide us on what significant is and what reasonable is and all of that kind of stuff. So you don't want to be the person who sets the precedent.
And if you're hired with us, you are already told we're a 24-hour-a-day business, 7 days a week, every day of the year. So that is, I mean, that's up front even in interviewing.
Yeah, that's true, but the thing is that if you
No, I
tell,
know what you're saying.
yeah, I mean, if somebody says, I can't work on Saturdays, then you go, fine, we'll have you work on Sundays. I mean, the fact that you're 24/7 only presents the fact that you can work around. Yeah. Okay. Next page. California employers with 50 or more employees are required to provide sexual harassment training to their supervisors every 2 years. New supervisors have to be trained within the first 6 months of promotion or hire. Your company employs 30 people, therefore you can't get sued for harassment. False, yeah. And that sounds stupid, but I've had employers say that I can't get sued because the law says 50. No, employers with one employee can be sued for harassment. You were saying something?
Oh, I said anybody can sue you
Yeah.
for anything.
Just about, yeah. 32, two employees frequently speak Spanish with each other when they are in the break room on their breaks. Is it okay for you to require them to speak English? No. So added protection about this, 2 lawsuits that went into effect, one in Los Angeles and one in Delano Regional Medical Center. You might have seen this on the news. Now, these 2 companies went even further. They didn't say everybody needs to speak English all the time. In Los Angeles, they said Spanish-speaking employees no longer get to speak Spanish, but everybody else continue to do your thing, which I don't know why they did that. And Delano did the same thing with Filipinos and said, Filipino people don't get to speak their languages, but everybody else go right ahead. So again, I don't know why, but Delano paid almost $1 million to settle that thing. So what the law says is that you are allowed to require people to speak English in order to get a job with you. You are allowed to require them to speak English in front of customers. And in safety-sensitive positions, for example, you're on an oil rig, everybody's got to speak English because somebody starts speaking a different language, then somebody gets their head blown off or whatever, okay? And in business necessity purposes, which is decided on a case-by-case basis. Other than that, you can't say, hey, not everybody speaks English here, and so, or not everybody speaks different languages here, so we all have to speak English all the time. You don't get to do that.
So what happens when you have a bunch of people in a break room and 3 of them are speaking Spanish in the corner, and then the 3 that don't know it go jump them, then they're in trouble?
Then they're in trouble. That's, no, the people who jump them are in trouble.
How do you make them numbers? If they come to you and say, I'm uncomfortable because they're speaking this language and I think they're talking about me, well, you can't do it.
Yeah, what you say is that the law allows them to do that. Mm-hmm.
Is it okay if there are some employees who are not able to understand or speak in English, but they only understand their own language, like Punjabi or some other language?
Mm-hmm.
Can we have them on the job, or we can have send them back that they cannot work?
Oh, sure, you can employ people who don't speak English if you want to.
But at the same time, we can also say no to them that they cannot work as well.
You can say you must speak English in order to be able to work
Is it
here.
a requirement to speak English? It is a legal requirement to speak English? To understand and speak English?
You can require employees to speak English in order to be employed.
Right.
Yes, yes. But there's not a legal requirement that people have to speak English to be employed.
Okay.
Can he say you got to speak Punjabi to work here?
Sure. Yeah, you betcha. You can require people to speak different languages.
Spanish required, so it kind of discriminates against all of us who can't speak Spanish. I see it.
Say preferred.
Yeah. Well, but the thing is, and we have to, one of the things, even though we have all of these laws, employers are still allowed to make money. And so if an employer says, look, I've got, most of my clientele is Spanish speaking, so you got to speak Spanish in order to work here. That's legal. Employers get to do that. Is that discriminating against people who don't speak? Yeah, it is, but it's legal discrimination.
The thing is, there are some places where there are certain instructions in English, or maybe in Spanish also, which are actually safety
Right.
instructions.
Well, what the law
That
says,
has to be understood by all the employees. And we feel that there are certain employees who are not able to understand that. So how to handle that?
okay, the law says if you have at least 10% of your workforce that English is not their first language, that a different language is their first language, then those signs must be in that language.
Okay.
Okay, so the thing is that you're allowed to not hire people if they don't speak English. But if you do hire people, then you have responsibility toward them.
Translate.
And that's to keep them safe. And so you got to make sure that all of that stuff, it's 10%. If at least 10% of your workforce is more comfortable speaking a different language.
Right.
Very good. 33, the only reason you can take FMLA is for a serious health condition that makes you unable to perform your job. False. Why else can you take family medical leave? For family members, yeah. Parent, spouse, child, domestic partner. If you are a custodial parent over a grandkid or something, you get to do that as well. 34, Sam just told you he needs to take some time off to care for his wife while she is recovering from surgery. He's worked for the company for 11 months. Is he eligible for FMLA? It has to be 12 months and 1,250 hours. 12 months and 1,250 hours. I'm sorry?
It can't be either or, it has to be.
It has to be and. 12 months and 1,250 hours. 35, Sam said he needs to take 1 hour of FML leave at a time. Can he do that?
Yeah.
Yes, he can, because he might have to go get radiation treatments or chemo treatments or what have you. Now, the thing here is that you want to be deducting those hours, right? Okay, so, I mean, the employee gets to have their 12 weeks, but you want to be deducting 12 weeks, keeping track of those 1 hour increments, so that when he hits 12 weeks, you go, okay, now we need to have a conversation about if you can be at work or not.
What's the family medical leave? It's after how many employees?
50.
50, correct?
Mm-hmm. 36, employers are required to provide sick leave and vacation to employees. False. They're not required to provide anything yet. 37, here's my example of alliteration. Sue's son is sick, and she wants to use her sick leave to take care of him, can't she?
Yes.
In the state of California, there's something called kin care, and it says if employers provide sick leave, half of that can go to taking care of their kin. And so do you keep track of that stuff? Are you sick today, or is that your son who is sick? I'm recording this. Oh, you've used your, no. Just let people, if you give them sick leave, let them use it for whoever's sick. Yeah. I'm not going to keep track of who's sick that day. 38, John had an accident a month ago, has been off work since then. You just heard from his doctor he's no longer physically able to do his job. Can you fire him now? No. What do you have to do? You have to go through the interactive process with him to see if he might be qualified for another job, or if he could do the job with a reasonable accommodation, etc. You can't just fire him.
Well, okay, your question says, the facts are, I know, and this person is physically unable, and maybe I've already talked to him, and cannot accommodate anything else. Now can I?
Yes, after that. But yeah, as the question stands, you haven't done that conversation with them. So, but that's a lot of employers go, okay, you can't physically do the job, you're done. No, you got to go through the interactive process. 39, Bob's ex-girlfriend is stalking him. He wants time off to go to court, get a restraining order. Do you have to give him the time off?
No, but it'd be smart.
You do have to give him the time off, yes. Now, do you have to pay him? No. 40, someone broke into Bob's house, stole a bunch of his stuff. Police caught the guy. Now Bob wants time off to go to court to testify against him. Do you have to give him the time off? Yes. Do you have to pay him? No. 41, Bob's son just got suspended from school. He tells you the only way his son can go back to school is if he sits in the classroom with him on his first day back. Do you have to give him the time off? Yes. Do you have to pay him? No.
Please explain why.
Because there are laws. There's a law for each one of these. There is, yeah. And so there's a law for victims of domestic violence. There's a law for victims of crime. There's a law for school suspension. There's a law for school activities. If you have at least 25 employees, your employees are allowed to have 8 hours of time off each month, no more than 40 each year, to go to their kids' baseball game or football game or play or what have you. You don't have to pay them, but there's a law for that. Yeah, so you know there's an app for that. There's a law for that. Thanks for laughing. 42, Bob lives in Bakersfield but works in Taft. He works 8 to 6. He has to leave for work at 7, doesn't get home till 7. Tomorrow's voting day. Bob tells you he wants to leave work early so he can go vote. Do you have to give him the time off?
Yes.
Only if he is scheduled the entire time and with commuting time and the polls are not open during that time. So there's something people get confused about with the voting, that employers have to give 2 hours off of work for people to vote. That's only if they're scheduled and their commute takes the entire time the polls are open. Now the polls are open until 8. And so Bob still has an hour after he gets home to go vote. And now you can, yeah. But you can't get to do that. Hey, just mail it in, stupid. You don't get to do that. You can say, Bob, you get home by 7 and the polls are open till 8. So you go to the polls after you get up or get home. 43.
So when
oh,
somebody's asking for that, because where I work, we're Monday through Friday, 8 to 5, so there's more than enough time for them to go before or after. But I had somebody ask me if we for
Uh-huh.
it, and they tried to reference the law.
Uh-huh.
So how would you determine somebody's commute time? Do you just have to ask them, well, how long does it take you to get to work? Or pull up their address and say, 20 minutes?
No, all you have to say is the law says that we only have to give you the 2 hours and pay you for it if you are scheduled and your commute is the entire time the polls are open. Now, the polls are open from 7 a.m. until 8 p.m. And so would that preclude you from voting? And if they say, yes, I live in Seattle, and so it takes me, all this time to get here, then okay. 43, Bob needs some personal time off, doesn't qualify for any of the federal or state mandated leaves. Do you have to give him the time off? No. It depends. What does it depend upon?
For the situation.
It depends upon what your handbook says. So this is one of the things, lots of employers get their handbook off the internet and they give it to people. Once you've done that, you got a contract. You got to oblige by whatever is in that handbook. I have looked through some handbooks that employers have. They're giving people all sorts of leave rights that they're not legally required to provide to them. But once it's in the handbook, then you got to give it to them. So it depends upon what your handbook says. That's one of the first things we say to employers when they call us and say, well, what do I do? What does your handbook say? You've got to follow your handbook for the most part. So 44, you want to fire Bob for taking so much time off, but HR tells you don't get to. So is it okay for you to make Bob's life miserable so he'll quit instead of having to fire them? No. That's a little something called constructive discharge. You don't want to do that. So unfortunately, some folks have employees like Bob. So questions or concerns at this point about information that we've covered?
If somebody is regularly late and calling that my car is broke or some reason, ranging from, say, 5 minutes to 2 hours, how do we handle that?
Write them up.
Write them out.
It's not your problem that their car broke down. It's not your problem that their alarm didn't work. It's not, none of that stuff is your problem. Okay? You need employees to be there from 8 to 5. And if they can't be there from 8 to 5 or whatever it is, then you let them know you have to be here. You got to figure it out. And you do that through documentation. So that when you do fire them, because they can never get to work on time, you've got that stream of documentation. Now, you're not legally required to have that documentation. If you're at will and somebody shows up late and you go, you're fired. Sorry. You don't have to give them any pre-warning whatsoever, and don't have to write them up and go through the progressive discipline policy unless your handbook says that and you have that's your common practice. At-will employee means I can fire you for any reason or no reason whatsoever without any notice whatsoever. But you don't want to do that because then you have constant turnover. And the rest of your employees will hate you. So that's why.
Just because you're at will doesn't mean that somebody's not going to try and sue you in the plan.
Well, yeah, because at will means you can fire anyone for any reason or no reason whatsoever, except for their race, color, sex, gender, sexual orientation, national origin, ancestry, physical, medical, religion, all that stuff. If they filed a workers' comp claim, if they filed some kind of complaint with the Department of Commerce. I mean, so there's a bazillion reasons that you can't fire people even though they're at will. But for the most part, if you just go, you know what, you're late, and I'm really mad today, and this was the wrong day to do it. So, see ya.
You can fire someone for file a workers' comp claim.
File a workers' comp claim? Okay.
You broke the company policy. Company policy says you are supposed to wear, steel-toe shoes. You didn't wear them, you got hurt, and now I'm turning. It's not a good idea because now the day's going to send them to go back to work.
Yeah. But you didn't file them for filing the claim. You fired them because they violated safety policy.
But if you fire them, they're almost 100% going to get unemployment, so you're just going to be paying them for the rest of their life anyway.
Yeah. Yeah, but unemployment is less than keeping somebody on board who's not doing their job. So, yeah, but I mean, that's the cost of doing business in California, unfortunately. And so there you go. Any other questions or concerns? All right, thank you so much for showing up. We do a workshop once a month. Thank you. We do a workshop once a month, usually, And so we rotate between customer service and communication and supervisory skills. And so hope you can show up for some or all of those. And Kelsey's got evaluations. If you'll just take a moment to complete the evaluation and then put on the counter on your way out, we'd appreciate it.